The will is the granddaddy of all estate planning documents. We all pretty much know what they are. My definition is that they're a piece of paper that says who gets your stuff after you die. Big question is what goes in a will? Now, someone a little more cheeky might say a bunch of legal jargon and some Latin, and that's actually not too inaccurate, but doesn't help us much. The question really is, if we are getting ready to sit down with an estate planning attorney, what information would we want to have with us about our will so that that meeting could go as effectively and efficiently as possible? My name is Gregory Singleton. I'm an estate planning attorney with Signature Law, and we're here to talk estate planning. In today's video, we are looking at the simple will as part of our essential series. And the will, there's a lot going on in wills, so I'm breaking that up into a number of videos. In fact, this is part 1 of 2 of the content that goes into a will. In this first video, we're going to look at basically probate instructions, and in the second part 2, or in part 2, we're going to be looking at gifts and individuals and people. Let's jump right to it, and we're going to cover the first 4 categories of things that goes into a will, starting with your fiduciary nomination. That's a couple big words there. A fiduciary is essentially someone that is tasked to act on your behalf, and they have to do so and keep your best interests in mind, even if they are in conflict with their own best interests. Basically, you're giving someone a job, and they have to do it keeping your best interests in mind. Now, there are 3 fiduciaries we're going to look at. The first is going to be the personal representative. This is the modern term for what we also know as the executor or the administrator, or if you're female, it'd be the executrix or the administratrix if you were back in the 1800s or maybe the 1970s. Their job is essentially to administer the estate. Gather up all the assets and give them to wherever they need to go, be it the government, a creditor, or a devisee or heir. Remember, a devisee is someone who receives something because of a will, and heir is someone who receives something as a matter of law. Now, the second fiduciary we're going to look at is the custodian of a custodial account for a minor. Minor being someone under the age of 21 in this case. Under the Minnesota Uniform Transfers to Minor Act, you can give a gift to whomever you want, but if the recipient of that gift is under the age of 21, they cannot receive that gift. Instead, it goes into a custodial account for that individual. Now, the trustee or the custodian of that account is just the trustee of that account. And how they work with the personal representative is the personal representative says, here's a gift for the child, let's set up a custodial account, and you're the trustee. I put it in the custodial account, and then the custodian is going to manage that asset until the child turns 21, at which point they can receive all the assets in the custodial account without restriction. The third fiduciary that we're going to look at in the will is going to be the trustee of a testamentary trust. Excuse me. Now, a testamentary trust is a trust that is established within the 4 corners of the document of the will, so that when someone dies, the trust comes into play, or comes into existence, really. And again, very similar to how the custodian works, the personal representative will gather all the assets that need to go in the trust, put it in the trust, or really just give it to the trustee to hold in trust, and the trustee will manage those assets until they are distributed or all distributed out because the trust ends or because it just runs out of assets. A couple things of note for fiduciaries: you can prohibit them as well as nominate them. You can say, I want Bob to be my personal representative, and if Bob can't do it, then pick someone else, but do not pick my ex-wife, Sally Joe. That totally valid to do, and the courts will generally honor that. The second thing you might note is that I hope I've said, nomination of fiduciaries and not appointment of fiduciaries. A lot of wills are misstated in that they say, we appoint this individual as personal representative. You don't appoint in a will, you nominate in a will. The court appoints based on that nomination and whatever the court feels is more appropriate. It's nitpicky, but it's accurate, and that's the fiduciary category of what goes into a will. Now, the second category of things that go into a will would be the authority for those fiduciaries, the fiduciaries' authorities. We've created these fiduciaries. We have to give them authority to do the job that we've tasked them to do. And this is done in two ways. First are the statutory authorities. These are generally repeated in the will. The very basic one you often see at the beginning of a will is for the personal representative. I authorize my personal representative to pay my debt and to satisfy my tax obligations. You're going to be able to do that anyways. We just like to repeat it in the will because it clarifies things, I guess. The second thing that we're going to do is list authorities that are given in the probate code. The probate code is, of course, the law that governs probate and what can go in and what cannot go in a will. There are various authorities that are granted to a personal representative under the Minnesota probate code, and we often just repeat those. The reason we repeat those within the context of a will, as opposed to say, please refer to Minnesota statute 524 point whatever it may be, the reason we do that is if the law changes, we want to preserve those rights and make it clear that these are the rights and the authorities that we're giving to the personal representative when we drafted this document. And if the law changed and changed what these authorities are, took away some, added some others, it may be included, may not be included, but we want to make sure that we preserve the ones that we had when we drafted the will. The next set of authorities are going to be the optional authorities. And there's a lot of authorities you can give to your personal representative as long as they don't conflict with the law. Some of these might include, for example, digital asset authorization, authorizing your personal representative to go into your email account and close it down, to go into your bank account and close it down, to go into your Facebook and whatever it may be account, shut it down, or gather the information necessary so that they don't violate the various federal laws that are out there. Another thing might be authorizing your personal representative to investigate your military benefits if you've served our country in the military. That's not something that's inherently in the authorities granted to a personal representative, but you can grant those authorities. The third thing that you're going to want to find, you hope you find, that you will find in your will is going to be instructions for probate. Now, all these are kind of instructions for probate, but this is a specific category. These are instructions directly for the court or instructions for your personal representative. They will include things like, I request informal probate for my estate. Remember, there are several levels of probate. There's formal supervised all the way down to informal unsupervised probate. The lower level being a lot less expensive, time consuming. You can sometimes do it without an attorney, and we just want to make things as easy as possible. And if you elect to have the easiest one possible, the registrar is probably going to drop you into that unless there's another problem with the estate. Another thing you might find in fiduciary instructions is a bond waiver. Under the Minnesota probate code, if you are appointed a personal representative, you're obligated to be bonded unless it is waived by the testator, the person who wrote the will, or it is waived by all devisees and heirs in the will. And oftentimes we are having our parents or our children or our spouse or a family friend that we trust be the personal representative, and we feel they don't need to have any sort of bond. It would be a waste of time and money, so we just waive that. Other things that will include will be tax apportionment. If you have a taxable estate, you're going to want to say where we're going to meet that tax obligation. Are you going to just pay it equally among all buckets of funds? Are you going to say pay it out of my retirement accounts first, or whatever it may be? And finally, this is just some examples of probate instructions, but a big one is a protective provision that might say something along the lines of, if I didn't identify someone or give someone a gift in this instrument, in this will, then I intentionally chose that to not include them. And what this does is it prevents people from coming out of the woodworks and saying, hey, that's my long lost dad from 35 years ago. We haven't talked in 35 years, but I'm his son, so I'm obligated to have a piece of the pie. The final thing in the first half of what you'll find in a will be instructions for minor children. And specifically, it'll be two things. Well, three things. One, it's going to be an appointment of a permanent guardian, so that when if you're the last parent standing and you pass, then we need to identify someone to raise the children to the age of majority. Not 21 in this case, but the age of 18 until they're adults. Second, we're going to want to give them various authorities to do their job. And third, we may want to limit a few things. We may want to say, you're the guardians, but I want my child, because of some disorder on the autism spectrum, to stay in the house that they've been raised in thus far, or something along those lines. There's a number of things that we can do just to make sure that the children are cared for in the way that we want them to be cared for. So this is part 1 of 2 of the content of a will. What goes in a will? This is the first 4. We heard fiduciary nominations, fiduciary authorities, probate instructions, and instructions for minor children, direction for minor children. I hope you liked today's video. If you liked today's video, please feel free to like and subscribe. It really does help support the channel. We release a new video every other Wednesday. In 2 weeks, we're going to release part 2 of this series, which is going to go over the final 4 things you're going to find in most wills. If you have any questions, leave them in the comments below. I'm a little bit late on responding to some of the questions, but you can always just email me. I'm usually a little bit faster on responding to emails. But otherwise, until next time, this is Gregory Singleton with Signature Law.